Good afternoon and welcome everyone to today's CLE presentation. We're going to start out with corporate perspective on the subpoena response. But before we get started, I wanted to read some housekeeping so that you're aware of what's happening. Thank you for joining today. For all the benefit of all the participants, attending these lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them to the question and answer space. If we cannot address your question during today's webinar, we will follow up after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have any follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Please note that Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. Participation in the live webinar must be on computer or laptop device. Credit is not available by joining via mobile device. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you'll need to enter the code word into the Q&A section of the screen. If you don't have a license in these states, you can disregard this. That code word will be provided during the course of the presentation. So, moving forward with the presentation, the first piece we're going to do is the corporate perspective on the subpoena response. During this first part of the conversation, this part will be presented by myself, Elizabeth Lampert, and Andrew Klump. Elizabeth and Andrew are part of the Dentons Bingham Greenbaum corporate team in the Midwest. They're both managing associates, Elizabeth in the Lexington office, and Andrew in the Louisville office. So in doing this, I wanted to briefly run through the agenda with you. You've met the team. We're going to go through the duties required when responding to a subpoena. Then we're going to help you analyze the subpoena that comes in, talk about establishing the team members to address the subpoena, the strategy to respond, some cost analysis questions because litigation costs money, and we certainly know that these aren't always planned expenditures. It's some part of some corporate budget, establishing communication parameters, and finally running through confidentiality and privacy issues, which are always an issue or question, forms, and then we'll leave it up for questions. And then we'll go into session 2. So real quickly, you'll see on your screen some of the duties that are required, which we're going to review in more detail during today's session. Duty 1 is, analyzing the subpoena, looking at the risk and the type of subpoena. We have a civil or criminal subpoena and what it's for. The duty 2 is establishing those important team members, both the team members that are within the whoever's receiving the subpoena, the corporation or the entity, and those that you may wish outside, either third-party vendors or supporters or outside counsel. And then the plan to respond to that subpoena. How's it going to happen? Who's going to be involved? What are the time frames and timelines? What information needs to be put together in order to put together the plan to respond? Duty 4, the cost analysis, because it's always important to plan what the cost and expense is going to be. How's that going to happen? Whose budget? What are the expectations for the expenditures? Then finally, these duty 5 is the communication parameters. And those communication lines are important both between those people putting together the response, the communications with outside counsel who may be assisting, any third-party vendors that may be putting together the technology to deliver, and then opposing parties, clients or customers that also may be involved in litigation that is come to you via the subpoena, and how you've gotten drug into this action. So that's an overview. We'll start going one by one through these duties, and I will turn it over to Andrew, Elizabeth, for the next slide.
Great. So thanks for the introduction, Bill. The first duty, as he mentioned, is analyzing the subpoena. So I think the first question you have to ask is, what is a subpoena? Right. So it's a tool that parties typically use to gather evidence during litigation. So you receive the document, and there's typically three types. You have a trial subpoena, which is used to require for witnessing and providing testimony at trial. There's deposition subpoenas where you can testify and also be required sometimes to produce documents with that. There's also production or document subpoenas where you are asked to produce a number of documents. You also have to look at the validity of the subpoena once you get it. So you need to have the name of the issuing court. You need to have the title of action and case number. They need to identify who is the subpoenaed person or corporation. That's going to be very critical when analyzing it, because you have to determine, is it an employee? Is it the company itself? Is it a vendor? So you need to make sure it's identified the subpoenaed person. You have to, if it's for a witness or trial subpoena, it should identify the time, the place, and the date to appear for trial or deposition. And if it's a document subpoena, it should identify the categories, the forms in which to produce, and identify the premises or objects to be inspected. Now, once you do that, once you realize, okay, I have a subpoena, arguably the most important thing is to make sure you figure out what the deadline is. Typically, it's 7 to 14 days, but you will need to check with your local jurisdiction, and it is required to be in the subpoena itself. And so my recommendation is always to, as soon as you get that and you validated the subpoena, make sure you calendar that deadline so you do not miss it. And again, I think we'll talk about this more in the next duty, but once you've received the subpoena, you need to start identifying all of the individuals that should be notified. So general counsel, in-house lawyers, certain corporate offices, and we'll get more into that later. Lastly, you should identify, is it criminal or civil? You know, they're is it an employee that, you know, had some sort of allegations against them, and then you're supposed to provide that related information, or is it a civil issue that is going up against your corporation or your employee? So there are requirements to respond, and if you don't, then you can be held in contempt or even have fines or imprisonment. So here in Kentucky, for example, ours in the civil side is $100 per day, up to a maximum fine of $1,000. So with all that as kind of background, I want to toss it over to Bill to let him give a little bit of a real life example.
Thanks, Andrew. Well, I think one of the things that we've all been involved, at some point we get the call that says, hey, somebody brings up to us, it comes to us as either in-house counsel or outside counsel through some corporate connection that says, we've got this subpoena, we're not sure what to do. And you know, sometimes these are very simple pieces, right? Some former employee or current employee is involved in some kind of action. They think they need records. Sometimes they have counsel, sometimes they don't have counsel. Things filter through, and it may be as simple as trying to figure out, okay, what's the litigation about, who's involved, how's this conversation happening? And so unfortunately, at any level, whether there's actually some litigation involving the corporation or involving one of our customers, some project we're involved with, how do we handle and respond? And so gearing up to look at what's happening and getting somebody, if you have in-house counsel, you are in-house counsel, looking at that piece. If you're not, making certain that you are working with the attorneys for the corporation or working with outside counsel. Generally, we say this, that if you are familiar because you have experience, either the company has experience in handling these kinds of matters and has people, or you have litigation experience as in-house counsel. But if you don't, even from our corporate perspective, you know, if we know it's simple enough and we can resolve it, fine, but involve the litigation folks, reach out to the litigators. in whoever is representing you to ask them the questions to make certain you are not underestimating or overestimating what needs to be done. And it's sometimes it's simple as somebody needs help and wants corporate records regarding their employment, and that's fine. We want to help our employees when sometimes we have an obligation to help our former employees, but let's make certain that we not only meet the deadline, but provide the information that's being requested so that we don't have somebody in our organizations that are held accountable for some reason that they did not properly respond to the subpoena.
Okay.
So looking at the second duty,
I just fried up one of the
and
eggs
Sandra, I
ate
see
a-
your
ate
question in
one
the
of
chat.
strips of bacon
I
that
believe
my
it's going to be
family
covered
did
in the
when I
third
cooked.
duty. If it's not,
No, not much,
we
but
do have the
something
questions at
tiny
the
of it
end, so
between
feel
now
free to
and
jump
then.
in. The second duty is establishing the team members. So as you might imagine, this can be a very large undertaking. So, and as Andrew mentioned, the response time is usually very quick. You're looking at 1 to 2 weeks. That's not business days, that's
Chatting with your son, I said,
actual
"How is it
days.
going?"
So you need to determine if outside counsel is necessary, and if so, to bring them in as quickly as possible. Part of that analysis includes determining where the jurisdiction of the subpoena.
Well, she
So if
already
it's
asked
from
us,
a different state
basically,
where
if we can cover
you're
all
not familiar with
if we
their
can cover his.
rules or their
I
response
think she was
times
getting to
or
that when
barred in that
she
state,
FaceTimed us
then certainly
the other
reach
day.
out
We was
to
out on
a firm like ours, where we have offices in nearly every state. So we're happy to help jump in and help you respond. Additionally, with the timing, does the company have the resources to handle this in-house? So two of those big analyses are software and staffing. Outside counsel is equipped to have, when we have this software, we have the staffing capabilities that can help you most quickly respond to these and most efficiently and effectively respond to the subpoenas. Once a subpoena is received, you need to alert all the necessary individuals. So that depending on where you are kind of in the hierarchy, that might be the general counsel, other in-house lawyers, certain corporate officers, potentially, again, outside lawyers, your IT staff and certain employees. IT is going to be really important. We're going to talk more about confidentiality and privilege, but one of the big key components to properly responding is, obviously, you don't want materials to be destroyed between the time when you receive that subpoena and when you're supposed to be responding. So a litigation hold should go in place. So that means even if you have a scheduled destruction in compliance with your retention and destruction policies, you need to wait on destroying any materials. And again, with IT, they'll be able to help do that from the electronic perspective. And also they'll be able to help you actually bring up the documents to have them provided, so they can be reviewed before they're determined whether they are responsive or not. They also should determine whether insurance should be involved, depending on whether you're a party in the suit or your company is a party in the suit, or your response to the suit, the subpoena as part of the suit will be covered by insurance. So most insurance policies require that the insurance company is notified. It's some qualifier, but usually promptly or something similar. So if you delay notifying, or the company delays notifying the insurer, it's possible that they will deny that claim if they claim that they are prejudiced by that delay. Bill's got another real life fact pattern for us to cover.
Thanks, Elizabeth. I think the one we certainly do not want to see as the subpoena comes in, that's really the fishing expedition. And we've all seen those subpoenas come in where they're overly broad subpoenas asking for all kinds of documents, and the client or the recipient is looking at it and saying, how in the world can we even determine where and how this is going on? We recently assisted in-house counsel in connection. Our client was a food processing company. They had constructed a new food processing facility in the Midwest. In connection with that, there was other economic development, local economic development organizations, and a construction company that helped put the new utilities in to serve. And certainly our client had been involved with the economic development incentives and as well as the determining the capacity for these utility lines, but really weren't involved in any piece of that. What the litigation involved was the construction company and the local economic development piece by virtue of the fact that we were a recipient, or the client was a recipient of some of the benefits, and obviously the utilities that were received, they got pulled into litigation. And it was very difficult because the construction company had national counsel. There was a lot of money at stake, which certainly raised the issues and questions, the amount of time that was being spent on litigation. It was important in that instance, for litigators involved from our firm to help in connection with that defense. And certainly making certain that we were only providing the limited amount of information that was responsive to the questions at hand, to our involvement, and not for all the documents involving the operations of our facilities and things that were typically asked for, but in fact were irrelevant to the litigation. And they were just fishing, right? They were trying to get as much information as they can. They were trying to involve the client to be part of the discovery process overall for the litigation, which they really only had a small piece. So in that instance, the team members were important in order to limit the need and expectation and the cost for the client in that litigation.
For those of you in New York, New Jersey, and other states that require the CLE code word, that code word is subpoena. One more time, subpoena.
All right. So now that we've kind of analyzed the subpoena, made sure it's valid, we've established some initial team members, how do we want to respond? We have to create a plan here to make sure how we want to proceed. Well, before we can proceed, we have to make sure we're following the right preservation and storage requirements. So even if we disagree with what the subpoena is asking for, or we don't want to respond wholly, we still have to take those steps to start preserving the documents in case one of our objections or motions later on gets denied. So there's limited document production where if you say they're asking for, you have a vendor and you've ordered 2 pieces of equipment from the vendor, and they want the subpoena is asking for the purchase orders and any communication, right? So maybe that's 10 documents, a couple emails, a couple purchase orders. That's easier. That can be mailed, hand delivered. You can scan and even potentially email those documents. But once you start getting the larger scale productions, you need to have a system in place on how you're going to both accumulate all those documents and then also deliver them. So if you can scan all the documents, if they're not PDFs already, and you can, previously people would use flash drives, now it's more common to use share files, or my favorite is the secure data room, because then you can see who's accessing, you can limit who has access, and that is probably the most secure way to go about it. There's also, when doing so, you also need to identify where you're looking for your documents. There's a lot of effort that goes involved to that. So, are you looking on your corporate servers? Are you looking at things that are potentially on people's personal computers, or things that are stored locally on work computers? And then historical archives that you might have. Another component to this, which is the Bates labeling, is a little bit of a historic name because it used to be known as Bates stamping. They would physically stamp the documents, but it's a unique numeric or alphanumeric identifier that you attach to each individual document and pages to make sure that each document page is easily identifiable and retrievable. So not just each document's labeled, but each page on each document. So for example, if the company's XYZ, you would have a production number of XYZ-00001 all the way up to XYZ dash 02500, so up to 25,000. So you have that. Then as part of this, you can have litigation holds that can make you really pause some of your general retention policies. If it's your company's policy to delete certain documents or kind of clear your archives of certain documents policies after 5 years, depending on the time period that the subpoena is requesting, you may have to suspend or at least temporarily suspend those policies in order to comply. So once you start gathering all the information, now you got to see how you want to move forward. That you can, if it's a party that you are willing to move forward with, so say it's maybe it's a friend of, or like a like-minded company that you want to work with, or you don't think that the ask is too burdensome, you can just simply comply and produce, and then you just have to deliver the documents to the location stated in the subpoena. On the other hand, if you don't agree with everything that they want you to produce, you can go into written objections. So you can serve the issuing party before the end of the subpoena period. So that if it's a 7 to 14 day window, you can reply with written objectives. And that does two things, right? That can, you can object to specifics of their requests in the subpoena, but it also buys you time, right? So it effectively shifts the burden to the requesting party, who must start a new action to file a motion to compel to enforce the subpoena. So those are those options. There's also a motion to quash, which that is that's still going to have the burden is going to be on the recipient party, and you can file a motion where the court actually should support your motion if one of the following options comes up. So there's a fails to allow reasonable time to comply. So if you have to generate 10,000 documents and they want to give you 7 days to reply, that's not reasonable. If they're asking you to appear for a trial in excess of 100 miles, or if they're trying to have you provide tangible objects in excess of 100 miles, or required to disclose privileged information, or subject to undue burden. Permissively, the court can look into trade secrets or other confidential research and development, but those are fact dependent. Speaking of undue burden, again, you got to look back to what you're using, right? So you're looking at the corporate servers, the personal computers, the historical archives. Where you're locating the documents is important in describing the undue burden. And when you make that request under your motion to quash, the court will often look to balance a few competing interests. So the relevance of the sought after evidence, the issuing party's need for the evidence, the breadth of the request, so kind of like the fishing expedition Bill was talking about earlier, the time period covered by the request, the adequacy of the description of the evidence. So if it's a vague description, then it can be almost impossible to locate everything that falls into that category, and just generally the burden imposed. But again, the burden of proof when you're filing this, when you're trying to prove this undue burden under a motion to quash, that's on the receiving party. But if there are too large of a burden, there are potential sanctions for the issuing party. So they could face penalties of the recipient's lost earnings or reasonable attorney's fees. Lastly, there's a protective order that a recipient can raise, which the recipient must expressly make that privilege or protection claim and describe the nature of the withheld materials in a manner that enables the parties to assess the assertion without revealing the privileged information. But along with that, you have to have a certification that the moving party has in good faith conferred or attempted to confer with the other affected parties in an effort to resolve the dispute without court action. So you have to talk to the, at least informally talk to the issuing party to try and resolve the issue. And you have to certify that you've done that. When looking at a protective order for something that may need to be protected, the court considers a number of the following. So disclosure will violate privacy interests. The issuing party, whether they seek it for a proper or improper purpose, whether it could cause a party embarrassment. Also, if the confidentiality is important to public health and safety, if the sharing of information among litigants will promote fairness and efficiency, whether a party benefiting from the confidentiality is a public entity or an official, and whether the case involves issues important to the public. And then when you're creating this motion for protective order, there are a few things that you can get as relief, which includes, forbidding the discovery or disclosure outright, but it could also specify terms, including time and place for the disclosure and the discovery. So making it at least confining the scope of the discovery and request. It can create a new or prescribe a new discovery method other than the one that's proposed. It could forbid inquiry into certain matters or limit the scope. It could designate the persons who may be present at the discovery. And it might, you can also require that a deposition be sealed and open only on court order. So there's a number of options to seek relief in your protective order. So lastly, I think we need to, I've harped on this before, but timing is incredibly important. So like I said, the written objections, protective order, once you start filing that motion, it does, within the 14-day window or the service date, it does push the burden back onto the other side. And so it's very important to keep the timing involved. The other component to it is you still have to follow the method of service that is typically done under requesting parties or issuing parties, all under Federal Rule of Civil Procedure 5B. So these aren't as, these last two are not the fun part, but the ministerial parts of this are extraordinarily important to get the timing, to make sure the service is done right. You can have the best written objections or motion or motion to quash or protective order, but if you don't hit the ministerial components here, it can damage your case. So with all that said, I'd like to just toss it back to Bill to see if there's any real life fact pattern he'd like to discuss.
Andrew, thanks. I think, one of the things we would like to believe that these duties all kind of mold together, right? When you're looking at one duty, you're looking at the other duties, and the duty to analyze we talked about earlier, and that's the same situation here. That our clients, whether they're our business clients or we're in-house counsel, the people we work for are the corporations. They're asking us to solve the problems, and when these subpoena issues come up from third parties that we're being asked to respond to, those are not planned events. And so the question is, what's the quickest, easiest way to resolve, to respond appropriately and to mark the times and do those pieces? But what's the solution, and how do we do this? And sometimes those solutions are, we don't need to be as formal, as Andrew's being with, finding or looking for protective orders or motions to quash. Sometimes there's other direct ways that we can handle those pieces by making certain phone calls or calling opposing counsel or discussions, and making sure we got the right people in place to help us, whether it's outside counsel or other resources. We had a circumstance recently where there was a state investigation involved the state securities commissioner. Call came.
Oh, well, Bill may have frozen there for a second. We'll see if he comes back.
Back to the piece of that. And
Bill, you wanna back up a second? You froze just momentarily.
I'm sorry, but let's back up to we recently had a client who had a defendant investigation from a state securities commissioner. They received a subpoena they were asking for a number of financial records, which certainly scared the client with respect to what they needed to respond, what the reason for the investigation was. As that came back to us, it flipped it to us as outside counsel. We then worked through, looked to the subpoena, answered some of the questions, but ultimately made contact with the State Security Commission's office and their counsel, ran through the pieces of it, and technically ended up delivering 12 documents in about 2 or 3 days. So that communication process to analyze, directly what's happening and to avoid having to file motions or objections, which in some instances are very necessary, but otherwise potentially practically can be avoided if you're analyzing correctly and making communication directly, sometimes with those parties that are issuing the subpoena, to find out directly what documents are really needed. Thank you.
Fourth duty is the cost analysis associated with responding. So in certain instances, the court can shift the cost to respond to the subpoena. So if responding to the subpoena is going to be overly burdensome, you can consider going to the court and asking for relief, in which case the requesting party would be ordered to pay for the cost of production. So a lot of these considerations by the court for shifting cost are very similar to the considerations that the court will have that it'll make whenever it rules on motions for protective orders. If the court determines that compliance with the document subpoena may impose an undue expense on the recipient, the court can shift the cost of compliance to the issuing party, and that's under the federal rules. The court may also consider the cost, fixing the cost prior to production, or it can look after production and look back and assess after the subpoena recipient produces the documents and seeing what that production actually looked like. There are numerous components for you as in-house counsel to determine whether this is going to be overly burdensome, whether it's worth looking into and speaking to outside counsel, or otherwise going to the court and asking the court for relief, some economic relief. Some of these considerations include the number of documents that are going to be produced, similar to Bill's prior, real life fact pattern. If you may think at the outset that there are going to be numerous documents that need to be produced, and in reality, maybe there are only a dozen. So in some instances, it makes more sense for the court to, have kind of hindsight and see what was actually produced. But it also might be obvious from the face of the subpoena that you have numerous documents that need to be produced. And of course, the more documents you produce, the more time it takes to look at them. Also, the number of documents that you need to review to look at what needs to be produced. So if you think that there are responsive emails, if you just need to look at one person's email inbox, of course, that's going to take some time, but that won't take nearly as long as having to look at an entire department's inbox. Also, whether confidentiality applies and the analysis that will have to be associated with determining whether confidentiality applies, and then also redaction. Of course, if you are going to have to redact entire or nearly entire documents, and even having to read, with a fine-tooth comb and figure out just exactly certain portions that need to be redacted, all of that takes extra time. Again, the accessibility of the documents. Are they already scanned into your system where you can pop them open and you can put them in a database and quickly look through each of the documents and see if they're responsive or not and mark them? Or if you're going to have to, if these are all paper files that are somewhere offsite or in the basement somewhere just in boxes, then you're gonna have to bring them all up, and maybe you need to scan them, maybe you need to physically redact them, maybe you have to then save them to a website or some other type of document management system. All of that takes time, and again, you have such a quick turnaround to respond to subpoenas that having the manpower, all of those things, and when things move faster, oftentimes, and you have to move fast, oftentimes that can be more expensive. So all of these are considerations consider the number of people who are involved. Again, are you having to get outside counsel? Is it something that you can oversee just 1 or 2 people and it can be handled? And then also, whenever the court's considerations include the non-party's interest. So if you're not a party to the litigation and you've received the subpoena, your interest in the case is the outcome of the case going to impact, and I say you and all of this, the company, is the outcome of the case going to impact the company's interest in some way? Is the company able to bear the cost? Is it a mom and pop shop? Is it a publicly traded company? How that impacts the court's decision whether to shift costs or not. And then whether the litigation is of public importance. Again, many of those are considerations that I'm sure you recall from Andrew's last duty about the motions for protective order. Bill's got another real life fact pattern for us on cost shifting.
Well, one of the things that clearly always is the case that we hear, and that is that this was not in the budget, right? We didn't plan for this. We didn't expect this. How do we limit the cost? Do we have to respond? How much do we have to respond? How are we going to manage these costs? So this is always a question, right? Because budgets are always important, and profitability in our clients and for our corporations are important. And so, one of the pieces always is, if we can use one of the procedures or ways to limit the cost or limit the documents that to be provided, that's important. But on the other side, we generally hear this too, right? And that is that, well, wait a minute, this is a critical vendor. They're involved in this piece. We want to provide some assistance. We want to be involved. We want to support the vendor. We don't want to have a bad outcome for them. So what can we do to make this happen? And that leads us down to, looking at the records and determining what information they provided. Does it need to be redacted? Is there sensitive information? That takes sometimes, in-house resources determine, is there matters to be redacted? How much are they? How do you organize those? How do they get delivered? Do we need outside counsel to help? Which is, again, a cost piece of that. And then sometimes we see circumstances where the corporation is saying, well, this involves 2 related parties. One we want to support, one we don't want to support. How do we balance that? Providing information? Can we choose information? There are ways to be more cooperative in how the information gets delivered. And as Andrew mentioned earlier, there's ways to be less cooperative. And so we do see corporations in some instances deciding for business reasons, using their legal resources to speed up and maybe absorb some of the cost in order to help or support those partners who are important to the businesses, and maybe be less supportive, be maybe somewhat recalcitrant, so to speak, in a way that is proper with respect to information that is provided that may help someone who is not favorable to the corporation.
Moving to our 5th duty, and real quick, I see a little bit, a couple comments in the Q&A box. The CLE code word that was read earlier, if you'll just type that into the question and answer box. So establishing communication patterns, obviously, again, with the tight turnaround, it's incredibly important to establish the communication patterns immediately. So part of that is internally, who's the team lead? Who is making the calls and coordinating people, making sure everything is being reviewed, reviewing what has been reviewed, spot checking, who's the person that people go to with questions, determining who that person is. And that should be both internally, of course, people who have questions internally, but then also externally, who is the person internal to the company who external counsel or whichever external person it is, who that person, those people need to go to within the company that is herding cats or otherwise organizing the response time. Then you need to have a communication plan, again, internally and externally. Maybe that is the same, maybe internally and externally, everybody's on the same call. Maybe that means you or whoever the team lead is has that communication with whoever is external. but setting up some type of check-in that's regular, again, can be different for different categories of people. If it's the people that are reviewing, the people you're coordinating with, all of those types of things. But I find it to be helpful if it's if you have a 7 or 14 day turnaround, maybe it's every day you have a check-in to see, okay, what's been the change since yesterday? What questions do we have today that came up or that came up yesterday after our call? Let's have daily calls to keep things moving along, and any questions that anyone has, they don't get lost in the inbox. They can be brought up immediately and addressed, and everything can continue to move forward. And we've alluded to this a little bit, but again, the timing, super quick. If you have thousands of documents that need to be reviewed, or you have thousands of documents you need to produce, contact the issuing party and speak to them and let them know, we have a lot of documents that we need to review potentially, or hey, somebody's on vacation. Regardless, we are going to need some time to respond to this. And this can be much more cost efficient by just going to the issuing party and saying, hey, this is what's going on. That can be much more cost efficient than drafting motions or objections and going in front of the court and asking for more time. Certainly possible that the parties can just agree to take a little more time to respond to those, or give you a little more time to respond to that subpoena, in which case, everyone's life's a little easier. Additionally, it might make sense to contact the adverse party. If the company and the adverse party's interests align, if you've gotten it from someone who's outside of the industry, or, the issuing party, the company's interests don't necessarily align with that party, you can also contact the adverse party or that party's legal representative to work on that response. That might tip off the adverse party and make them just decide to go ahead and independently move to quash or modify the subpoena that was issued by the issuing party, because they may have the personal right or some kind of privilege that the subpoena and their responsive information implicates. Bill's got another fact pattern for us on this one as well.
Yeah, well, I think that the important part here is that generally we're all really busy people. There's a lot of things going on, have a lot of responsibilities, and the same for the internal employees or staff that may, whether it's the IT department or somebody in supply or logistics, whatever it is, that is going to have to drag these documents out. They have jobs they're doing every day, and now we're asking them, in-house counsel's asking them, or outside counsel's asking them to find records and provide those records, deliver those records, in addition to their normal responsibilities. And so, depending on the timeline and the time frame, there may be need to set aside time for them to obtain the records, deliver the records. I think it's also important, we talk about lines of communication, to make sure we know who's in charge, right? Is in-house counsel in charge? Is outside counsel in charge? Or is there somebody, supervisors in charge of getting the records, so that, and as Elizabeth mentioned, regular catch-ups to say, where are we, what are we doing? Do we have any roadblocks? Is the information where we thought it was? Is it coming through? What's happening? Are people working? Are people at work? What's happening to make that happen? And then I think the other side is to be brutally honest, when this has got to get done, this is going to take the time to get it, make sure that it's getting through, and the timeline, right? I mean, I think generally we want to make sure that we have timelines that are communicated so that the documents, there's no surprises, nobody's pulling, a 24-hour review, or we have people there till midnight trying to look at documents, or we're going back to opposing counsel and saying, hey, look, at the last second, we need more time. Sometimes that happens, but to the extent we can avoid it and plan for it, that line of communication is really important.
Allie, I'm going to touch on a couple of overarching concepts, specifically confidentiality and privacy issues when you respond to the subpoena. Only non-privileged documents that fall within the scope of the subpoena should be produced. So they're privileged or they're outside of the scope of the subpoena, naturally, they should not be produced. You should also consider whether the documents are subject to an existing confidentiality agreement. So if if there's a possibility that the documents are subject to an existing confidentiality agreement, as outside counsel or as in-house counsel, or you should coordinate with outside counsel, someone should review those confidentiality agreements and see what obligations that you have to the other party under the confidentiality agreement with respect to the subpoena. So it's not uncommon, as Bill has alluded to, we're corporate attorneys. So we draft lots of confidentiality agreements from day to day. Many of those confidentiality agreements have some obligation of the parties that they have to notify the other party upon receiving a subpoena that could require them to produce documents that fall underneath or that are protected by the confidentiality agreement. So sometimes that means that the other party will have a chance to respond. They're under the confidentiality agreement, they're required to have at least the opportunity to look at the subpoena or go to the court and try to fight production of the documents. But either way, if there's a possibility that they're implicated, that the confidentiality agreement is implicated, certainly look at it and see if you need to get the other party involved and to what degree and the timing for that. The recipient should also review potentially responsive documents to determine whether they can be withheld based on attorney-client privilege, work product doctrine, if they're trade secrets, if there's some other recognized privilege or protection that requires them to be either withheld or redacted. So even though those documents could potentially be withheld based on privilege grounds, that doesn't mean, unfortunately, that you just can be like, oh, great, I don't have to send any of these emails with so-and-so about certain things. Unfortunately, you still have to, in most jurisdictions, create a privilege log, and that logs each of those documents that you're withholding that would otherwise could be responsive to the subpoena and the grounds for withholding them. If there is attorney-client privilege, if there is some other reason. And then when considering whether something could be protected because of a trade secret, again, trade secrets, what is a trade secret varies from state to state, but consider whether the documents used as a whole could reveal some type of trade secret rather than just on a document by document basis. And again, that might be a time, there are times with subpoena production where we as lawyers just have to do it. It requires certain legal knowledge, but there are other times when the business folks need to be involved. And I think it's with trade secrets, that's certainly a time to get the business people involved or otherwise communicate with them and get another perspective. We also, because confidentiality determinations and redaction and all of those types of issues they're really important, they're also can be a little bit tedious. It's great to have another set of eyes, and whether that is if you're handling it in-house, if you have an associate of some type, associate general counsel or someone else, other counsel that are looking at it initially, and then you as GC or you as associate general counsel are then looking, even if it's spot checking, if it's you are doing it in-house and then sending it out to your general counsel to take a look at before it gets sent over. All of that is a great idea because it is, once it's out, it's out. Even if you send it to the other side and you realize it's privileged and you can otherwise have it produced or have it protected, it's still, once the information is out, it's out. So pre-production document review by another set of eyes is really important. And then you might need to otherwise just designate confidential, it's confidential documents. Just because a document says that it is, is marked confidential, it still needs that or the privilege assessment. Having the word confidential on it does not necessarily, as we all know, mean that the document is confidential. And just because a document is not marked confidential does not mean that it is not necessarily otherwise protected by some type of privilege. Bill, do you have a fact pattern or any comments on this one?
Yeah, I just say too quickly, one of the times the last 2 years, we had a circumstance where one of our clients had to deliver and rightfully so a number of purchase orders, but we got the business people involved, and one of the concerns was the pricing, right? There was pricing on those purchase orders and discounting. This involved a large furniture manufacturing concern. And they were nervous about the fact that that was going to disclose, some discounting patterns and provide their competition with some additional information if it ever got out. And so we worked through those questions to protect them, to do that pieces. The other thing I was thinking about was that we had a circumstance where a large manufacturing client got connected into a litigation by subpoenas involving an acquisition that had happened a number of years ago. But in connection with that acquisition, there were a number of licensing agreements, some which were still alive for product and some which were not. And in connection with that, we had to go back to the origination people who held those license agreement in order to discuss with them how we were going to respond and what the responses were going to be in order to make certain we were not inadvertently disclosing information about the licensing arrangements or that intellectual property. So it is important to talk to the business people and let them inform or discuss kind of the connections that may help raise issues with respect to either trade secrets, business confidentiality, or obligations that may be in place that somebody has forgotten about regarding separate contracts or agreements that were previously executed and maybe still be in place.
So last, I think, but not least, is I think it's important for us to talk about forms. So we've attached here, you'll get the materials. These are, I think, just basic Westlaw links to checklists. But if you're in-house, outside counsel doesn't apply to as much, but if you're in-house, you need to have a checklist put together of what happens when I get a subpoena. And so that you can use some of the materials from today, but you should have some of those communication lines, at least the preliminary. Eventually, it's fact specific, but you should have a game plan of what you should be doing when a subpoena comes in. So I think it's just important to be prepared there. With that said, I think we are near the end of our time, but we wanted to leave some of it open for questions. If you all would like to input any into the question and answer section.
And I'm sure you'll have questions that come up. This is so riveting. I'm confident hours from now you all will have questions that pop up in your mind, and you can see our email addresses are there on the bottom. So feel free to reach out. Phone numbers are there. Give us a call. However we can help, please do let us know.
So Leslie had a comment of, are there any issues with accepting service in general for subpoenas? I don't know, Bill, if you want to take this or not, but to me, it should be the individual listed on the subpoena.
One of the questions always for the acceptance of service is whether or not, that goes back to the analysis, right? And we always want to analyze and make an analysis of, as we is there jurisdiction and what does that look like? Sometimes that involves if you don't have prior litigation experience, it may be worth discussing with an outside counsel with litigation to say, where does this take us? And if we can avoid it and we want to avoid it and there's not jurisdiction, then we don't respond, right? Or we work on a non-response and we talk. But you do step into jurisdiction, and that's one of the questions that always ought to be analyzed up front as to whether or not there is jurisdiction. Do we accept service?
Deb wants to know, do you have an example of when someone actually went to jail for not responding to a subpoena? I don't, but
I don't either.
Sounds like a terrible way to spend, for failing to do some paperwork.
Yeah. And generally, I think the difficulty in non-response a lot of times is that, you could have avoided cost and expense by having a conversation. And so I think if there are issues, when in doubt, what we always say is reach out, get advice from outside counsel or from litigation support, whoever that might be. But also, if you don't have that, contact the other side and have a conversation, because generally there's a lot of things that can be resolved by those conversations. As long as you're making certain you're still protecting your client, protecting the corporation, so that you're not exposing things that you want to hold in confidence.
Right. And I think be proactive. Don't ask the morning that the documents are due. Ideally, sometimes things come up, but try as early as possible to reach out to the other side, or reach out to general counsel, or whoever the party is that you're reaching out to. Obviously, being as proactive as possible is ideal.
That's great. Well, it's great being here today. Appreciate your attendance and appreciate your questions. We will make a handoff to Cheryl and Meg, who will have the second hour in the presentation. We will try to follow up with any questions that we didn't get answered today, and there will be a hard copy of this presentation, which will be distributed following the completion of the seminar or the webinar. Thanks.
Bill, Elizabeth, Andrew, thank you. That was really great. I enjoyed listening in on that. I bet Cheryl would agree with me that from the litigation perspective, when you're looking at a subpoena, I mean, you guys are totally right that you just want to be proactive, because you could waive your objections. You could waive your chance to quash the subpoena. Oftentimes you can send a letter that says we don't have anything, and the other side will leave you alone. But if you ignore it, it will not go away. So Cheryl and I will briefly introduce ourselves, but we're going to talk about protecting company secrets and what happens, the best way to protect data and information, but then also what happens as the party seeking data and information, and what are some permissible methods outside of regular discovery protocols that allow you to do your research for a transaction or in litigation. So I'm Meg Christensen. I am a litigator in Indianapolis. I do a lot of attorney discipline defense in addition to business disputes. So I frequently will get called on by other law firms or lawyers to help them resolve issues. The idea for this topic actually came from a matter where I represented a client in a patent dispute who had patent counsel, but he had allegedly communicated with a former employee of the plaintiff to get some information. And there was a flurry of briefing on a motion to disqualify. And that's when they brought me in. And so it's an interesting topic to dig into, and it is a topic with real practical applications, both to in-house counsel and outside counsel. Cheryl, do you want to introduce yourself as well?
Absolutely. I'm Cheryl Oswald. I'm a partner in Denton Cerroti's Tuscaloosa and Birmingham offices. I practice commercial litigation, and actually right now have a case. It's a multi-jurisdictional case that really the other side, I am deposing mainly former employees. And so it really is great timing with some of these issues we're talking about, reaching out to employees or former employees in the context of this CLE. So it's great timing to be talking about these subjects.
Thanks. So we'll, just to give you a kind of our overview of what we're doing today, I mean, in a nutshell, you're going to walk away thinking, oh, I should know the rules in my specific jurisdiction where the issue comes up, and then I should follow the rules, right? And that's what you're getting out of your 1 hour of ethics CLE. But we'll talk more specifically about defining the privilege and which conversations are actually privileged. I'm sure most of you who are in-house frequently have people on the business ops side copy you on everything, and then you say, why am I on this? And they say, oh, so it's privileged. And we all know it's not privileged just because you're on it, but we'll delve into that a bit. We'll talk about the obligation for lawyers in-house and outside counsel handling information, and just how to ensure that confidentiality is protected. And then we'll talk about, this question of when we're speaking with active employees or former employees of the opposing party, what can you do as counsel? And then finally, what about that dreaded moment when somebody accidentally produces privileged information and some details on waiver and what your obligations are as the receiving party? And if at any point you have questions, we will try to keep an eye on that Q&A screen, but feel free to stick them there and one of the two of us will get those answered. So talking about, just generally, what is the scope of the attorney-client privilege? We all know it protects from disclosure communications between a client and a lawyer for the purpose of giving or receiving legal advice. So it doesn't attach to every communication with a lawyer. So if I'm representing you in litigation and you call and you say, what should I wear to that fundraiser we're going to Friday? It's not privileged. It's just because I represent you. In the in-house context, you sitting in on a general meeting for your strategy as to investing in India doesn't necessarily render it privileged if that is more of a business strategy meeting versus legal strategy. So looking at different cases, I love this case. It is, so as an Indiana practitioner, a lot of the cases I pull for these are Indiana and 7th Circuit cases. But Cheryl and I both have conducted some 50-state surveys to kind of back this up. But I love the way this case sums it up. So if legal advice of any kind is sought from a professional legal advisor in their professional capacity, then the communications relating to that purpose made in confidence by the client are at the client's choice, permanently protected from disclosure by himself or his legal advisor, but it can be waived. So the important thing about privilege versus confidentiality is that it really is a privilege against forcing somebody to testify. It's not exactly the same thing as confidentiality. Confidentiality is really a lot broader. It's not limited just to communications. Confidentiality would include anything you observe or just generally learn in the course of a representation, versus privilege really relates to those communications and just says, nope, you cannot call Meg to the stand to testify about what you told her. And Cheryl is going to get more into the Upjohn case. There we go. And that, of course, is a hallmark case with respect to confident or privilege when dealing with employees. But not every communication between an attorney and his client is privileged. And that's because sometimes they don't have anything to do with your legal strategy, or maybe, if it's just an employee of the corporation you represent, they might not actually be somebody who can help dictate your legal strategy. Did the slides go away for everyone else? There we go. Okay. And then also communications from an attorney to the client are privileged only if they relate or would in some way reveal the substance of a client confidence. So that's really broad, right? When I'm doing privilege review for a document production in the course of discovery, I tend to mark even meeting invites as privileged on a first pass, because I say, okay, well, what's the meeting about? I don't want somebody to pull that accepted Outlook invitation that says meeting Ray Jones litigation out in a deposition and say, okay, well, what was this about? And then have a fight about it. So I tend to withhold that stuff. And that might be a little bit controversial, but I really doubt anybody wants to see those anyway. But the point is, it's not, hey, what time are we golfing on Tuesday? It's, hey, can we talk about Jones, right? The active litigation. And then Cheryl is going to talk about communications between counsel and employees.
Yes, and along those lines, Meg, I actually had a case within the last year or so that some of the documents produced showed in-house counsel or an attorney and the other side talking about vacations and going out on a yacht. And it was within the context of, it was mixed in another email chain, but obviously they produced those because, as you said, those types of loose communications are not privileged. So here we're going to look at communications between counsel and employees. And I think the overarching theme we're going to hear is that those communications really need to be confidential in nature. and they need to be for the purpose of giving legal advice. Meg had mentioned the hallmark nature of the Upjohn case, and in Upjohn, the Supreme Court really looked at what's the scope of employees that the privilege could apply to. And the court in Upjohn said, you know what, it's not just the control group of employees, which the Court of Appeals had defined. They defined the control group as the officers and agents responsible for directing the company's actions in response to legal advice. In Upjohn, the court said, we're not just going to let the privilege apply to the control group. It will apply to in-house counsel's communications with those officers and agents, but it's also going to apply to the in-house counsel's communications with mid-level employees, lower level employees, because we don't want to inhibit the in-house counsel from being able to talk to those other employees and find out what they need to find out in order to be able to give legal advice. So it's a great case, I think, for counsel, for lawyers, because it really broadened the group or confirmed the broader nature of the group of employees that privilege can apply to. So I'm trying to, there we go. Communications, as we've already talked about, we're talking now about communications with employees in adverse situations are not privileged. Examples would be negotiating employment contracts, settling tort claims. And so there are limited situations in which I guess the company and a particular employee may be in an adverse situation. And if that happens, we want to be particularly mindful that our attorney-client privilege may not apply in some of those contexts. We have a great, well, actually, we'll get to that in a minute. We've got these other two cases first. I was going to mention the Owens case, but first we'll look at Cold, which said where both parties are present, declarations to an attorney are not privileged communications. And that really makes sense, right? If both sides are present, I think you know, most would agree that an attorney-client privilege would not apply in that context. In the Hanlon case, communication in the presence of an adverse party was found not to be confidential. In Hanlon, it was a situation where the parties were coming together for a deed to be drafted by an attorney, and the court said, no, where you were both present, we're not going to have the attorney-client privilege to apply for one side. And then the case I just mentioned, the Owens case, was an interesting situation where there was an employee of Best Beers who negotiated an arrangement where he helped his company sue a brewing company, and said, as part of his reward for that time, the hours spent helping with litigation, he would receive a contingency fee. At one point, it was 50%. It went down to 1/3, but nevertheless, he was going to receive a contingency fee for his work on behalf of his company. He was ultimately let go and then sued the company over the contingency fee. In that case, the court found that the attorney-client privilege did not attach to the former employee's negotiations with Best Beers lawyers as to his employment contract related to that litigation, because those communications were adversarial and were not for the purpose of advising the employer. Again, I think it just goes back to when you're in an adversarial setting with an employee within the company, we want to just pay careful attention to, is this an adversarial situation where our communications internally may not be privileged as to this particular situation. And the quote here, because the discussions related to what Best Beers would pay Owens, they could not be seen as confidential as to Owens. The attorney-client privilege does not exist unless the communication is confidential. What we talked about earlier, is the communication truly confidential, and is it made for the purpose of giving legal advice? Interestingly, in Owens, there was the phrase, and I've seen this in multiple cases related to attorney-client privilege. The court looked at whether honoring the privilege, whether allowing the privilege to apply, was parallel with the search for the truth. That's the phrase they used. And so in looking at this as in a case-by-case basis, there may be times when a court decides that it's really contrary to the ultimate search for the truth to allow the privilege to apply. And that's what they decided in the communications in Best Beers, in the Best Beers case.
It's funny to me when courts go back to, we have to honor the search for the truth, because the other quotes you see a lot that Cheryl and I were pinging each other with in preparation for this seminar was the underlying notion that privilege is one of the most important obligations that lawyers have in order for our entire system to work, that clients need that trust in order to share any sort of information. And certainly when you look at the confidentiality rule 1.6, that at least has some corollary impact, it is very broad. But then the exceptions that come out are truly to prevent significant bodily or financial harm. So not if it's already happened, but if it can be prevented, and then to if it's information that really can't be obtained anywhere else and is vital to the search for the truth. And so I do think the rules, and privilege is common law, and so there's always this balancing when judges start looking at things like that. I would, as I sit here and we 3 slides ago, we said, okay, well, it's not confidential if you're opposed to your employee, your current employee. And it starts out as a head scratcher for me. I mean, Owens is an obvious instance where, okay, active current employee, where their interests are aligned in many respects, does have this adverse interest with respect to one thing. But I think a really common example is also just any sort of employment investigation. Any of you that have done internal investigations or participated in them know that the first thing you do when you sit down, whether it's your practice to hand over a written copy of the "I do not represent you" speech, or just to make the speech and then write in your notes, Upjohn gives pretty clear warnings if you are adverse or potentially adverse, or that employee is just a witness, it's not privileged. Now you still have confidentiality because it's something you're learning in the scope of the representation, but there's no privilege with that individual. And so you do need to be careful to tell them, I don't represent you. And we'll zero in on that a bit more later. So when I want to talk about handling and producing client information, and so we're just going to talk about rules. They are largely uniform. For this presentation, since it's national in scope, we are using the model rules of professional conduct. Most states are verbatim. Those that aren't, they're very, some of them have different numbering or different word choices, but by and large, there's a corollary. So we all know we have to provide competent representation. And when ethics nerds talk about competence, there are a couple types. I mean, you have to actually have a fully functioning mind, right? So if you have a degenerative disease, or maybe some sort of addiction issue, or something that maybe you can't handle a full load, you might still be competent to be a lawyer, but maybe you need to be part-time or whatever the deal is. That's one form of competence. Of course, there's legal competence as in sound mind and of legal age. But generally, Rule 1.1 is talking about, do you know the subject matter? Do you have the skill to learn the subject matter? Can you make the time to learn the subject matter? Everyone, you don't actually have to know everything the day you get out of law school, but you have to be willing to learn it and devote the time to learn it. And then comment 8, and this is, I think, what's important for what we're talking about today. So there are lots of comments. We're not going to read them all to you, but in order to maintain your requisite skill and knowledge, you have to keep abreast of changes in the law and its practice. So you have to come to CLEs. That's why we have to do this. You wouldn't want a heart surgeon using 30-year-old technology to bust into your heart. You don't want a lawyer going to court citing old rules. So Comment 8 tells us you have to understand and stay abreast of the benefits and risks associated with relevant technology. And it was interesting when this phrase, including the benefits and risks associated with relevant technology, was added to Comment 8. There was this big debate in the ABA committee, and it was, well, shouldn't we put some actual standards in there? Shouldn't we say it should be 2-bit encryption, or you need this kind of password, or you should share everything on Google Docs or whatever it's going to be? And the consensus very quickly became no, because anything we put in writing will be obsolete by the time the rule book lands on people's desks. And so that's why it's this really vague standard. It really is a rule of reason. But inside and outside counsel, when we are dealing with privileged and confidential information, really do need to make it part of our jobs to understand how to best protect that information. And it used to be, hey, don't throw away a bunch of binders with sensitive information in the dumpster behind the company, right? Get it shredded. So think about what is today's equivalent of shredding when it's electronic documents, and who do you entrust with that obligation?
Yes, I think that's so true. And as you were saying about keeping abreast of changes in the law, I think, and it's something we learn in law school is issue spotting, right? And so hopefully CLEs like this one and others that we all attend just help us be able to spot those issues. And even if we're not maybe fully able to address them ourselves, we at least become aware and know that it's something we should look into or engage others to help us with. So rule 1.3 on diligence, we all know that a lawyer should act with reasonable diligence and promptness in representing the client. This rule really addresses, as comment 2 says, the workload that an attorney takes on, and we're all obligated to not take on more than we can do. I really think for purposes of these rules, something that comes to mind is just, I think, partly the communication between in-house counsel and maybe outside counsel and others about expectations as far as, the turnaround time on certain work products. I think, as others have mentioned throughout the course of today, really both hours of the CLE, the communication is so important to know what the expectations are as far as how quickly things are needed. But we do have to obviously control our workloads. Rule 1.3 in diligence, comment 3 states that, I'll just paraphrase, but it talks about procrastination, right? And that a client's interest really can be heavily affected, severely impacted by procrastination. And I think that's where the communication and planning of timeframes, how much lead time does a client need in order to be able to review the work and get a review back to you. And as I'm sure you all know, that greatly differs depending on the size of the organization and who might be involved in reviewing the attorney work product. And so this rule even mentions there are times where procrastination can even be detrimental to claims. If you goodness forbid, miss a statute of limitations deadline, those sorts of things. The rule does, or the comment does, talk about that while we have a duty to act, timely, that the rules do not preclude us from asking for or agreeing to a reasonable extension where there is no prejudice to the client in doing so. And so I think that's where having great working relationships and with other attorneys and civility among those that you're practicing with and on the other side of can really be helpful when you have those good working relationships. And in the rare instance you might need an extension, can ask for that and it not be an issue. That's very helpful.
So to go from the concrete rules to something a little more valuable or helpful as your takeaway, right? If you were to clip this slide, or you've received the materials and tag this one and say, here's a checklist of, you go to your next performance review with your boss and you want to say, here's what I'm going to do this year to help the organization. It would be really great if your organization has actual written standards and protocols for what is a business versus a legal communication. That will help potentially with the flow to your inbox. If you're not just copied on things for, because people think it might make it privileged, but more than that, it really aids with privilege and confidentiality review if and when your company is responding to a subpoena or responding to discovery in any piece of litigation or in a other ADR proceeding. Have a protocol with respect to actually marking documents, whether it's you actually save it with privileged in the subject matter, or if it's an email, it's always in the subject line. I mean, it could be anything, but that way there's a clear protocol. The danger of a protocol like that is then if somebody forgets one time, and you're fighting about whether the document is privileged. So you do have to, if you implement some sort of business standard or organizational standard, you want to make sure people are following it. So you might also want to include some sort of audit of that periodically to make sure it's happening. Documents, and so I did not put standards in this slide as to which secure transmission you should use. That's a really technical question. And that's one of those things that I say as a lawyer, oh, I pay people to figure that out for me, right? So your organization pays somebody to figure that out, but make sure you're doing that and make sure you are, again, auditing that on a periodic basis. So for instance, at Denton's, I can't send and receive client documents by Google Drive or Dropbox. We use Microsoft OneDrive. And I'm not throwing that in there as an advertisement. It's because somebody who specializes in that has determined that that is a safer way to protect client information. But then when I work with certain hospital and banking and financial clients, they require even higher levels of protection. And, you can't even send emails without an encrypted system. And so some of that's industry specific, but make sure that as the lawyer engaged in the process, you are being thoughtful about what you're using. There was another way that we kind of came to this topic. I don't know if any of you followed the trial related to the radio personality who defamed the Sandy Hook victims and said the whole thing was a made-up conspiracy. The reason I'm bringing that up is that in his trial, his attorney had produced an entire folder of information from the defendant's phone, but hadn't really done much of a privilege review. And one piece of it was that whatever file share site he used, he just produced the entire folder rather than a subfolder that contained the actual information he meant to produce. And so that's one of those things that's just a mistake. It's not necessarily unethical, but it's absolutely malpractice, right? Would be my kind of high level view of it. So that's one of those, get the right platform to protect and transmit the data. But then also when it's time to produce and transmit, look at what you're sending one last time before you hit send. That's how you avoid copying opposing counsel on a privileged email or sending a bunch of, your entire folder of privileged documents to opposing counsel. And then as far as communications, I wanted to talk about confidentiality agreements and joint defense and common interest agreements. So we won't have another slide on confidentiality agreements, but on the same token as organizational standards for defining what is a business versus legal communication, if you actually have confidentiality agreements with the employees who are going to have access to sensitive information, that really helps down the line when somebody says, well, I'm going to interview your former employee, because they're not going to tell you in advance, but then that employee has a legal agreement that they're bound by so that they know what was confidential and what wasn't and where the line is. And if you have to move to disqualify opposing counsel and they have clearly interviewed your former employee about something that fell within the scope of the confidentiality agreement, that makes your job a lot easier in getting rid of them. Joint defense and common interest agreements, and I'll call them common interest agreements because plaintiffs can use them too, or people aligned on the plaintiff side. And you can use them in transactional settings as well. So anytime sensitive information has to be exchanged between parties, so licensing negotiations or people with similar interests in litigation, you can have a common interest agreement. And the key consideration is that the nature of the interest of the parties is identical and not just similar. So if there's some divergence, you can't actually get a common interest agreement and just share information willy-nilly. But if you really do have the same end goal, then and it is same legal goal, not just, a commercial goal to increase profit or something, then you can have that agreement. The doctrine is limited, I already said, to this identical interest. But the purpose of it is if Cheryl and I each pretend we're not at the same firm, and we each represent individuals responding to a product's liability claim, and maybe we're representing carriers, right? And we think it's some other party. As long as our interests are aligned, or we could even have a limited scope common interest agreement, our clients could exchange information freely. She and I could talk with one another about legal strategy, and you get a lot of efficiencies out of that. And it's still confidential to the outside world. And that's the key. That's your protection. The downside is that what we tell each other, our clients then they know and they can use. And then you can put language in your common interest agreement to say, well, if our common interest parts ways, you can't use this information, but they still know it. And so you want to be careful who you hitch your wagon to. Another quote, just if you're ever litigating this stuff, I like to put these long quotes in PowerPoints. So you could pull it up and have a few case sites. But you do, if somebody's trying to defeat your privilege or confidentiality and say, hey, those two parties didn't have a common interest, you do want to be able to show that you had a common goal and that the reason you were sharing documents was to cooperate in that goal. But also there's no requirement that it be a written agreement. Makes me cringe every time I say that. I would like a written agreement, right? That's a no-brainer. But it does give me some assurance, at least if I'm new in a case and say there's a deadline coming up and I start working with co-defense counsel on something, we can do a quick email that says, we'll paper up our common interest agreement, but we agree our interests are aligned. Respond yes, and I'll send you that document you asked for. So you can at least get that stopgap. But all of those things are ways to help define and protect your privilege and confidentiality. Ooh, the keyword is protecting. So if you are in New Jersey, New York, Kansas City, and Pennsylvania, please type and submit the CLE code in the Q&A box. So down at the bottom on my screen. Oh, you're all doing it. All right. Cheryl's going to talk about the obligations of somebody seeking information from a former employee. Oh, sorry, Cheryl.
Oh,
hands
did
off.
I?
No, we both advanced, but
Oh, okay. Do I need to go back one?
it was just the heading.
Okay, very good. Yes. So in talking about communicate, well, I think first we're going to look at communications with a person represented by counsel. This says in representing a client, a lawyer shall not communicate about the subject of the representation with a person a lawyer knows to be represented by another attorney in the matter. Unless they have the consent of that person's attorney. So I think this makes sense. We know, I think we probably all know that as counsel in a case, I would not reach out directly to the other side if I know that they're represented by counsel. Now in comment 4, it says that the rule does not prohibit communication with a represented person or an employee or agent of such person concerning matters outside of representation. And so in this example, there's the existence of a controversy between a government agency and a private party, or between two organizations, does not prohibit a lawyer from communicating with non-lawyer representatives of the other side regarding a separate matter. So the way to think about this, and when you think about two parties, both parties being represented by counsel, as counsel for one of those parties, if I have a legitimate reason to be communicating with the other party outside the context of the litigation that we're in, I can certainly do that. These rules don't prevent that. Also, and it's covered in these comments, I think it's important to remember that really two parties to a case can still communicate without their lawyers being present and without, just without the involvement of their attorneys. And there are limited situations in litigation in which, there have been times I've even encouraged a client, hey, their counsel may not be open to hearing this from me, but if you want to reach out directly, or if they reach out to you directly, you guys can certainly have that conversation. I have a case right now where the CEO of my client and the CEO of the business on the other side have had lots of communications over the course of the relationship that could possibly resolve part of the litigation. And so we have parameters in place that if the CEO on the other side reaches out to our CEO, we kind of have a pre-planned strategy as to how he's going to approach those communications, particularly regarding settlement. So those communications can obviously go on. In comment 7, it talks about, in the case of a represented organization, this rule prohibits communications with a constituent of the organization who supervises, directs, or regularly consults with the organization's lawyer concerning the matter, or has authority to obligate the organization with respect to the matter, or whose act or omission in connection with the matter may be imputed to the organization for purposes of civil or criminal liability. It goes on to talk about communications with former constituents not requiring the consent of the organization's lawyer. And it goes further to say, if the constituent of an organization is now represented by their own counsel, then in order for us to contact the constituent, we would need the consent of that constituent's attorney, not necessarily the consent of the organization's attorney. In communicating with a current or former constituent of an organization, a lawyer must not use methods of obtaining evidence that violate the legal rights of the organization. And we've cited Rule 4.4 here, which at least Alabama's Rule 4.4, and I think the model rule as well, talks about a lawyer shall not use means that have no substantive purpose other than to embarrass, delay, or burden a third person.
Okay, so what is,
I'm
now we
sorry.
did it twice. That's okay.
I'm sorry.
That's okay. I think everyone here has participated in enough Zoom presentations by now that it's an art, right? Not a science.
That's right.
So, so what do we know about communicating with former employees beyond the fact that they can't be represented, or if they are, you need permission, and practically that permission should not be, if they reach out to you by email, don't respond to them, forward it to their counsel and say, is it okay if I respond? Because you really do want a paper trail on that sort of thing. It's one of the few rights in any state's professional conduct code that actually belongs to the attorney in terms of waiver. The attorney has to waive it, versus confidentiality, it's the client, or privilege, it's the client, or basically anything else. So you can't seek privileged information. See, Art, nice typo. That's my fault. Sorry. Okay, you can't seek privileged information when you are interviewing a former employee of an adverse party. So if it's a deposition, the context that Cheryl mentioned at the top of the hour, opposing counsel is going to be there and they'll object if you're seeking something that's privileged. You can go meet at Starbucks, or they can come to your office, or you can go visit them in their hospital bed, whatever, but don't start asking privileged questions. And if they start going that direction, stop them. And we will get into some of the consequences of that. But it depends on what you reasonably should know. And then if you do stumble into potentially privileged information, the cases tell us that you can't conduct your own privilege review. You really do have to notify the other side and let them know. So we're going to go through some cases. We're going to go through some rules. That's what we're going to do here. In the interest of time, I'm going to just pick a couple of these to go through, but you'll have the sites if this is an issue that you're facing, or you think you want to get somebody disqualified later. And of course, we would always love to brief that issue, because it's a fun thing to fight about, because it's very fact specific. I'm sure my clients don't like hearing me say that it's fun to fight, but So Harris Davis Rebar, and most of these cases are district cases as opposed to appellate cases because that's where these fights happen and it's not something that tends to be appealed. But this case, Harris Davis Rebar wanted a declaratory judgment that it wasn't required to contribute to a pension fund under ERISA, the Structural Iron Workers Local Union Pension Fund, right? So the lawyer for the fund met with a former employee of Harris Davis Rebar, and he's a disgruntled employee, or he viewed the fund favorably. Maybe he was part of the fund, who knows? He then shared 3,000 emails, including hundreds of privileged and confidential emails. And the fund didn't disclose to Harris Davis Rebar's counsel that it had received the documents, and it proceeded to do its own privilege analysis. So then, of course, eventually, when Harris Davis Rebar learns of this, well into the litigation, probably when they're whipped out at some deposition or another, they seek to disqualify counsel for the fund. And here, the Northern District of Illinois did conclude that the counsel should not have accepted the documents from the former employee. And at a minimum, they should have notified HDR when they showed up. So, because some of these cases, you'll see that somebody just forwards the documents. And you're like, where do these come from? So you've already received them, but you don't open them. You tell opposing counsel as soon as you realize what they are, you just stop. But the court did not disqualify counsel here. Here, the court just banned the use of the information derived from those documents and didn't allow the former employee to testify, which, depending on what's in those documents, that could be really significant because some of those might have been things they could get in discovery anyway. And you see that in some of the cases, the court will say, well, if the former employee produced documents that the company also produced, that their former employer also produced, those can be used, but anything that the employee produced that wasn't produced, you're banned from using. And so it can truly be very significant. We'll talk about agro services. I'll skip Chamberlain Group because it's kind of the same result, and it's also Northern District of Illinois. The Agro Services versus Sophia Lee and Company was a real estate purchase dispute. And there, the seller's switched attorneys partway through the transaction. So then the buyer's attorney met with seller's former attorney, and they discussed privileged information. And Agro Services sought to disqualify buyer's attorney for seeking out this meeting with their former counsel. And the court granted that motion to disqualify because it's not permissible for an attorney to deliberately invade an adverse party's attorney-client privilege. That's one of the things that it's 4.3 tells us. You can't induce somebody else to break the rules. Couple more of these cases. So we have to talk about P.T. Barnum's nightclub. Mostly because it is 1:40 in the afternoon, and anytime you talk about a strip club in a CLE, people's ears perk up, and later they remember it and say, those presenters were so funny. But it's, of course, the most salacious case has to come from my home state. So go figure. So P.T. Barnum's nightclub is a place I've never been, and it is an exotic dancing club that apparently, according to the case, every night they have female dancers, but on Saturdays they have male and female dancers. So this woman with the last name Duhamel was there on a Saturday night for a bachelorette party, and an exotic dancer attempted to lift her onto the stage. And she said, no, don't lift me up. And he did it anyway. He lost his balance. He fell over and he landed on her. So there's your visual. So she sues the nightclub for her personal injuries. And during the personal injury suit, plaintiff's lawyer contacted the former manager at the nightclub to talk about protocols and whether he's an independent contractor and all of that. And if you ever need to cite a case about whether somebody is an employer or independent contractor, this one goes through that analysis in great detail, and it's memorable. But that's not what we have to talk about here. So they get the affidavit from the nightclub manager. He does not have independent counsel. He also does not really have any access to privileged information because he's not part of, he was no longer employed by the nightclub by the time the lawsuit came around, by the time they spoke to him. So he didn't know the lawsuit strategy. And he wasn't involved in kind of the corporate strategic decision making either. And so PT Barnum's tried to strike the affidavit and bar it from use. And that motion, the Indiana Court of Appeals said, no, you're allowed to use that affidavit. It's fair game to go to a witness as long as you didn't try to induce him to violate privilege. And here he had no privilege. And then to keep it short, I'll just say that in Tomasian is interesting because there it's a discrimination and harassment claim. And the plaintiff's attorney ended up first interviewing another former employee of CD Peacock, but then also representing her with respect to her own separation agreement from the company. So then CD Peacock tried to have that counsel disqualified on the basis that his later representation of the second employee might have revealed some sort of damaging information. And the court said, no, you're allowed to represent another employee about a different topic as long as the subject matter doesn't overlap and you're not prying for privileged information from that client. So their disqualification was denied. Cheryl, I won't touch the controls.
I think all of that's such great information. As far as speaking with former employees, which is something we've done in that case that I've referenced, two takeaways I think there are, as you've said, to really steer clear from asking about things that would invade the attorney-client privilege. If there is one, you certainly wouldn't want to do anything that would intentionally invade that. And then also just remembering when you're talking to a former employee that they may be deposed and they very well maybe ask exactly what you said to them and what they said to you. And so in those contexts, I think my partners and I have been, hypersensitive about what we say on those phone calls or in those meetings. All right, so we're looking now at sanctions for improperly seeking privileged information. And I think really the overarching point here is that given, as Meg referenced earlier, the sacred nature of the attorney-client privilege, and the U.S. Supreme Court has actually called it a sacred privilege. And given that it is the oldest privilege related to confidential information under the common law, there very truly have to be consequences for trying to invade it or trying to break it intentionally. And so that's what we see here with sanctions for improperly seeking privileged information. Disqualification of an attorney from a particular case, although that may seem really severe, it does guard against the risk that confidential or privileged information could be used unfairly. So unfortunately, it's, I think, a situation where there has to be a really strong consequence for attorneys trying to disregard attorney-client privilege that would apply to other parties and their counsel. In Cargill, the court said, the quote is that the courts have not only the supervisory power, but also the duty and the responsibility to disqualify counsel for unethical conduct prejudicial to his adversaries. Have a note from Cargill that says the court's authority to disqualify an attorney arises from the court's inherent power to preserve the integrity of the adversarial process. So, and as the last case, Guilford reflects, unfortunately, doubt, or depending on whose side you're on, I guess maybe it's fortunately that this is the case, but doubts must be resolved in favor of disqualification. And this particular comment reminded me of one of the canons of judicial ethics that we often see, where judges are required not just to avoid impropriety, but the appearance of impropriety. I think there's a similar tone here, where even if it's questionable, they're going to likely favor disqualification of an attorney who may have improperly sought out that information or, misused or abused attorney-client privileged information. And that,
Yes. Okay, so I was also kind of scanning the questions. I didn't see any substantive questions. If you did have one, maybe put it back in there so it's at the bottom of the feed. Somebody did ask what was the code word, and in case you didn't get that answered, it was protecting for hour 2. So Rule 4.4, this one's an interesting one. It is one that it doesn't actually tell you what to do. So at least Model Rule 4.4 and Indiana's version, and Illinois and Kentucky and Ohio and Florida all say, if you receive a document or ESI and it relates to your representation and or you should know that it's privileged, it's an email, to between opposing counsel and their client, you should know, you have to promptly notify the sender. Now, some states like Alabama go further and actually give you guidance. And they say you have to notify the opposing party and then abide by their reasonable instruction. And if you disagree with their reasonable instruction, you go to the court. But what the model rule says is very little. And the comments say, yeah, that's right. We don't tell you what you have to do here. This rule does not address your legal duties after you receive it, other than to tell them. So great, real helpful. Comment 3 goes on to say some lawyers might choose to return the document or just delete it. And I will say that generally when this has occurred for me, that's what I've chosen to do. And that's what I've seen opposing counsel do if they're inadvertently copied on an email, which I've seen happen exclusively when somebody's sending an email from their phone and, at 7 at night, and somehow it autofills and their big fat thumbs like copy the whole world. So, you'll get that email back from opposing counsel that says, I don't think I was meant to be copied, I'm deleting. Well, it still lives out there in their server somewhere. And it raises the question to me, before you delete that, don't I have to consult with my client? Because now I have that information and I have an obligation to use what I know to advocate for my client. Indiana's rules no longer refer to zealous representation, but many states do. So it does put you in this tough spot, especially if, unlike Alabama, your state doesn't tell you what to do. So then you look to the rules of evidence and the actual trial rules. Cheryl?
yes. So here we're looking at receiving potentially privileged information, and what does the Federal Rule of Evidence 502 require? So Part A looks at disclosures made in a federal proceeding or to a federal office or agency and the scope of the waiver. When the disclosure is made in a federal proceeding and waives the attorney-client privilege or work product protection, the waiver extends to an undisclosed communication or information in a federal or state proceeding only if, 1, the waiver is intentional, 2, the disclosed and undisclosed communications or information concern the same subject matter, and in fairness, they ought to be considered together. So this subpart A is really looking at when a disclosure is made, and what the scope, what other information does that apply to? And then subpart B looks at inadvertent disclosure. So you're not intentionally making a disclosure. This is accidental, mistaken disclosure. When made in a federal proceeding or to a federal office or agency, the disclosure does not operate as a waiver in a federal or state proceeding if, 1, the disclosure was accidental, inadvertent, 2, the holder of the privilege or protection took reasonable steps to prevent the disclosure. That one's important. And 3, the holder promptly took reasonable steps to rectify the error, including, if applicable, following Rule 26B5 B, which talks about, if produced, the party claiming the provision must notify and state a basis for the privilege, not just say, will you delete this, or I'm claiming privilege here. In subpart C, it talks about a disclosure made in a state court proceeding. When the disclosure is made in a state proceeding and is not the subject of a state court order concerning waiver, the disclosure does not operate as a waiver in the federal court proceeding. If the disclosure, one, would not be a waiver under this rule if it had been made in a federal court proceeding, or two, is not a waiver under the law of the state where the disclosure occurred. And that makes sense to me that that a state court, a disclosure made in a state proceeding would not likely have the same effect on a disclosure made in a federal court proceeding. It seems to make more sense that a disclosure in a federal court setting or federal proceeding would be more likely to impact a similar disclosure in a state proceeding, if that makes sense. Sorry, my computer is frozen.
Okay, I'll tap it.
I don't know if you're able to advance. I'm not able to. Okay, so subpart D, this is the controlling effect of a court order. And so it talks about how a federal court may order that the privilege or protection is not waived by disclosure in connection with a litigation pending before the court. Subpart E talks about the controlling effect of a party agreement. An agreement between the parties on the effect of a disclosure is binding only on the parties to that agreement and not necessarily the other parties to the case or to the proceeding. And subpart F talks about the controlling effect of this rule, the different settings in which the rule applies. And then we also have, for purposes of the rule, definitions as to what is considered attorney-client privilege. It's the protection that is applicable, that applicable law provides for attorney-client communications, and then also a definition for work product for protection.
I'll advance because I think.
Yeah, sorry, I'm not sure why I'm not
So
able to
just
here.
I was thinking we were meant to go until 2:10, but I have confirmed we're meant to go until 2. So we have 4 minutes. So we will rush through the end of this so you guys get to the end of it. So it is interesting that Rule 4.4 doesn't always give you the answer to your ethical obligations, but the evidentiary rules do. And then the federal rule 26B5B, and then most states have a corollary rule that essentially say, if I send you privileged information and then I realize it and I tell you and I've timely notified you, and timely is based on when I discover the inadvertent disclosure, not when it was disclosed. So it could be a year later, but if I learn about it and then I tell you, I can say to you, I didn't waive it, that was accidental, please send it back. And you either have to destroy it, sequester it, or send it back. And if you want to use it, then you would sequester it and then go to the court and seek a determination as to whether privilege was waived. Cheryl's going to talk about maybe one of these cases about determining waiver.
I'll be super short. And you have the cases here and the quotes, which hopefully will be helpful to you. I think it's important to note here that these courts really, I think, look at the totality of the circumstances, whether an inadvertent disclosure is truly inadvertent. If we look at the first case, we'll see. Yes, if we look at the first case, it talks about a finding that a single piece of paper inadvertently disclosed out of more than 3,700 documents did not amount to counsel's failure to adequately review the production. So the courts here are going to look at what measures did the attorney take in advance to review. There are some cases in here that talk about, hey, the attorney didn't look at the information until after it was sent. That's probably not going to rise to the level of a truly inadvertent production, but the court will look at the totality of the circumstances, and they will look at it on a case-by-case basis to determine whether a production was inadvertent. Simple.
Oh,
if you can advance, I'm sorry.
Yep, you're okay.
Yeah, I think one other note on these would be, I think it's just so important to allow sufficient time to truly review document production, even when you're using sophisticated systems to help you mark documents as privileged. Just allowing allowing the necessary time to go back through and double check and try to just do everything in your power to prevent those kind of disclosures from happening on the front end. As Meg said, a lot of times even double checking the sender or the recipient line of an email of something that simple can be enormously helpful. So just slowing down and taking the time to really put the time into reviewing document production can go a long way to avoid a lot of the issues noted in these cases.
So one other thing you can do is at the very outset, get some sort of agreement. I would wager that anyone here who's participated in any federal litigation has entered into a discovery protective order. I certainly do it in state court in most instances as well. And I always include some sort of clawback provision. Sometimes you have to negotiate the scope of that, but so you can put this inadvertent disclosure language into a clawback provision. Still leaves you with the dispute about whether it was an inadvertent disclosure, but it just gives you some more assurance there. And it's just a good way to solidify your gentleman's agreement at the beginning of the representation that it's good for everybody.
Yes, and along those same lines, Meg, I think, and I know it's not within the scope of our presentation, but protective orders on the front end. Even if it's not an inadvertent disclosure, there just may be things that you are concerned about disclosing to the other side document-wise, and having a protective order in place that can protect that information not to be used outside of the scope of the litigation can be so very helpful and provide a comfort level there. I guess the last piece here is talking about sanctions for failure to follow the rules. And so we see these three cases talk about disqualifying counsel that failed to follow the rules. I think this is in line with what we looked at earlier, where because of the sacred nature of the privilege, there truly has to be consequences to deter attorneys from potentially trying to gain an advantage through using information that should be privileged for the other side. I think
that brings us to the end of our content. We've enjoyed chatting with you all today. I don't see questions in the feed, but our email addresses are here, and Cheryl and I are both happy to talk about any of these issues anytime. So thanks for being here today.
Absolutely. Thank you so much.